Please, Your Lordship. Lordship, I beg to mention item number 8. Item number 8, Your Lordship.
For the state respondents.
On pre-made by the petitioner, this is matter after 3 weeks.
Lordship, similar prayer for item 9 and 10.
9.
Yes, Your Lordship. 9 and 10, Your Lordship.
Same order.
Right, Your Lordship.
Exactly as mentioned number 7, you receive.
Why?
You receive in this case, I got the Barbin instruction that's ban has not been withdrawn, but written not yet has received.
Ban not withdrawn.
Not yet. But written not yet been received. You receive.
So,
That's compulsion environment, my lord. Ban, if it is verbal, my lord, what are the steps? The ministry has said that you send me the proposal for withdrawing. We will take into consideration. So whether the respondent authorities has taken the steps or not.
yes, so
That's what, my lord.
that is the only thing we are waiting for.
My lord.
I'm waiting.
Instruction, you have not, have you got any written instruction?
Not yet. You receive.
Then verbally, how can we? So even then, Mr. Jha,
My lord.
if there are no instructions, so the ban will remain.
Definitely, my lord. If the ban is, that means this petition becomes infructuous, my lord. Until unless the ban is not
Until unless the ban is withdrawn,
withdrawn.
then
only
you are
the-
eligible for
the
appointment.
for appointment, my lord. So the ministry has said that you send me a proposal. What are the steps you wanted to take? More than 7,500 lists are there, my lord. They are yet to be. So ministry had permanently not banned, my lord.
Should have got some written, communication, Mr. Debnath.
No written communication has come, you receive. So let it go after 3 weeks, you receive. Let it go after 3 weeks.
Last chance. Mr. R. Debnath, Leonard, CGC, has submitted that he has received verbal instruction as regard the query made on account of on the issue of the ban for appointment on compassionate ground, as to whether the same is still in place or not. And to this effect, it was submitted that the ban has not yet been withdrawn. However, no written communication has been received in this regard. Mr. Debnath has submitted that he may be allowed to be communicated with a written communication, and the same to be filed before this court by way of an affidavit. If nothing is forthcoming, the matter will be heard definitely on the next date fix. As prayed for, this is matter of 3 weeks.
For number 12, I was praying for some accommodation.
Objection.
How long?
2 weeks.
On prayer made by the petitioner, on prayer made by the Leonard DSGI on behalf of the petitioner, not objected to by respondent. This is matter after 2 weeks.
Ditto.
My lord, I pray for the item number 6 to be adjourned as the conducting counsel, Mr. S.K. Hassan, is unable to come today due to personal difficulty.
You're for?
S.K. Hassan, Mr. S.K. Hassan.
I am for the petition.
Respondent
for
number
petitioner?
5.
Yes, please.
Respondent?
Yes, I am for the petition.
Yes, any objection?
Yes, I have no objection, my lord. Because it is long pending, always taking time.
Should be. Anyway, on payment by the respondent number,
Item number 6.
respondent
5.
number 5, on grounds of personal difficulty by the learned counsel, the same not be objected to by the petitioner. The prayer for adjournment is allowed. Let's this matter up to 2 weeks.
Your Lordship, I would like to mention item number 4. I would like to pray for 2 weeks' time, Your Lordship. I would like to pray for 2 weeks' times.
You are appearing for?
A respondent.
Respondent. On payment by the respondent not objected to by petitioner, let's this matter up to 3 weeks.
May I please, Your Lordship? I beg to mention item number 11. Your Lordship, since my senior, Sir Mahanta, will not be able to appear today on medical grounds, can this matter come after 3 weeks, Your Lordship?
I have no objections, Your Lordship.
No objection.
Prayer for adjournment has been made on the ground of the on the ground of inability of the learned senior counsel who is conducting the matter, as he is said to be not well. On premier, the same is allowed. Let's this matter to 3 weeks.
Much obliged, Your Lordship.
Your Lordship, I beg to mention item number 1, Your Lordship. The conducting counsel is out of station due to some personal difficulty. Can the matter be taken up after
Item
3
number
weeks? We are for the petitioner. Item number 1, Your Lordship.
Yes, order. Yes. No mentioning as far as the order column is concerned. Let the matter come up and we'll see how it goes.
Please, Your Lordship, I beg to mention item number 5. The conducting counsel is out of station. Let the matter be posted after
You're
2
for?
weeks. Petitioner.
I am for the state respondent, my lord.
Hardly any matter left on payment by the petitioner. This is matter for 2 weeks.
Supplementary costless, item number 1.
This is the bail application, lords. Now primarily the session court notes, lords, there is the contention raised is that I have not cooperated with the investigation. Notice under 41A was issued. I have joined investigation twice. The contention raised by the investigating officer is that I have not joined and that's why they have arrested me. I am requesting, lords, the case diary may be called up, lords, and the state wants to file a reply, lords, because without the case diary, 41A says that once there are reasons, if I have joined investigation, there has to be reasons in writing that can be enumerated only from the case diary, my lords. So my request will be, my lords, if they want to file a formal reply, there can be a formal reply, or if they want to bring the case diary, my lords, we'll argue it.
So case diary will be called for.
Yes,
Mr. Sulai?
Lordship, in fact, your Lordship, that reason has been recorded by the IO in his. If Lordship, for the time for the, can you come to page 39? Brief facts, your Lordship. This is, your Lordship, in compliance with the order passed by the Honorable Full Bench, your Lordship, in PIL 40. Then, your Lordship, kindly come to the next page. why the IO, in spite of the fact that a notice under section 41A has been issued, and then the
And subsequently he was arrested.
subsequently arrested, Your Lordship. The law is, permit us, Your Lordship. Section 41(3) is very clear, Your Lordship.
That is-
Reason has to be recorded. So these are the reasons, Your Lordship. And
What are the
anyway, Your
reasons?
Lordship, I'll have the case diary with me.
When?
Lordship. If you can have on 20th July, Your Lordship.
No difficulty, my lords. But the only request is, my lord, the case diary should be here, my lords, so that it can be argued.
Definitely.
Yes, that's the only request.
Heard the counsel for the petitioner. Also heard Mr. Andy Shulai, learned AAG for the state respondent. At the outset, the learned counsel for the petitioner has submitted that this petition may be heard on production of the case diary related to the case wherein the
Shalang 39, Your Lordship.
related to
PS 39.
PS Shalang PS case
39.
number 3912 of 2022.
Your Lordship.
Mr. Shulai has also agreed that it would be prudent for this court to produce the case diary before finally deciding on the matter. As prayed for, accordingly, the prosecution is directed to produce the copy of the case diary on the next date fix with the latest status of the case to be status report of the case to be filed by the IO. As prayed for, list this matter on 20th July.
Offline.
I have a small request, my lords. Please, my lords, if my lordship have page 11 of my bail application, ground I. Lords, I have specifically pleaded that there is a pick and choose investigation which is done. So I am requesting, my lords, that there is a CCTV footage, because all police station, it is mandatory there has to be a CCTV footage, my lords. The investigating officer should answer this also. In fact, if possible, my lords, they can put it in a pen drive and give it in the case diary.
Let the
Lordship, in
case
my humble-
let the case diary be produced, and we will see.
Lordship, accused has no right to dictate.
No, I am not.
What
I
IO should
am.
do, Your Lordship.
Lords, I am alleging now. Tomorrow, I am only saying now. The investigating officer, when he appears, he should not say that I am handicapped. I don't have this material with me. I am only requesting that it can be summoned by the court. It can be in a sealed format with before the court. Don't give it to me.
We'll see how it will be relevant to the.
My lords, then my
It
lords,
has no relevance, Your Lordship.
my lords, my case is that there is a pick and choose attitude by the investigating officer.
How would that affect you?
Lords, because
You-
that
you are
affects
before
me,
this-
lords. In fact, they
You are
say
before, you are before this court with a prayer for grant of bail.
yes, my lords.
So merits will have to be looked into.
Lords, my lords, in that
And
case,
the,
my lords.
the court will produce the CD, and if necessary order will be passed.
Yes, my lords. In that case, my lords, then I will file a judgment, my lords, of the Delhi High Court. I know it's not binding, but it primarily draws the inference when there is a pick and choose attitude by the investigating agency. The court has to act as for the safety of the person and has to grant bail. I'll argue on that point, my lords. It is a famous case of Ankur Chawla. He was an advocate, my lords. He was giving a bribe to somebody. The person who got the bribe, he was arrested. The lawyer was not arrested. The court said that you can't have a pick and choose attitude. So all I'm saying that there is a pick and choose attitude by the
You advance your argument on the.
I'll do that.
Fix, and we'll see.
Deeply obliged.
Item number 2.
Yes. My lord, I have filed this miscase, my lord, in a pending matter, my lord. My lord, this miscase is for stay of the advertisement, my lord.
Yes.
Now, what had happened is, my lord, there were 2 writ petitions, my lord, filed in 2021. That was last working day before the vacations, my lord. I had mentioned, and this matter was moved. Now, there are 2 writ petitions. One relates to 4 post advertisement of 2017, And this writ petition relates to 2 posts in 2020 advertisement. The urgency in the 4 posts was, my lord, during that time that there were notification for interview was issued. So therefore, certain interim orders were passed by your lordship. Now, in this writ petition, since that time there was no urgency, my lord, your lordship had said we will consider it. But now we have come to, my lord, to the knowledge that the department is pressing on holding the exams. Now, the subject matter of the writ petition is, my lord, the rules provide, my lord, that 33% of the post are reserved for promotion and 67% for direct recruitment. Total sanctioned posts are 21. Now, out of 21, 15 posts have already been filled by direct recruitment, exhausting the 67%. These remaining 6 posts, which are now advertised for direct recruitment, my lord, these are reserved for promotion, my lord. So that is the subject matter of the writ, my lord. Kindly have that, my lord, my application today, my lord, in the connected writ petition. Kindly have page 7, my lord, annexure 1. So, my lord, this writ petition is writ petition number 465 of 2021. And at page 7, annexure A1, my lord, is writ petition number 466 of 2021. Yes. So, certain interim orders were passed, my lord, with respect to 2017 advertisement. So, my lord, my prayer is for similar orders, my lord, for the 2020 advertisement, which is the subject matter of this writ petition, my lord. So, I pray for notice, my lord. If they wish to file their reply, they can file, my lord.
So, the advertisement has been floated?
Yes, my lord, in 2020.
And applications have been received?
Yes, my lord.
So, what happened thereafter?
Thereafter, my lord, we approached this honorable court, my lord, 2021, once we came to know about it. But since...
and the process was stayed?
My lord, there were 2 advertisements. Since the 2017 advertisement was at the final stage, so certain interim orders were passed by your lordship. Okay. But in this 2020, no interim orders were passed. That is why, my lord, now I have approached by way of this application that certain interim orders may be passed. Else, my lord, the entire writ will become infructuous.
And your grounds are that the department is contemplating or has already taken steps for...
The advertisement has been issued. Now they are contemplating to proceed because there is no stay from this honorable court.
Where is your basis for that?
My lord, my basis, my lord, kindly have my writ petition, my lord. I'll take your lordship's rule. If your lordships has my writ petition.
Yes.
At page 69, my lord. These are the rules formulated by the department, my lord, in 2017.
67?
Page 69, annexure 11.
Yes.
So, my lord, these rules are called, my lord, the Meghalaya Transport Service Rules 2017. Now, my lord, kindly have page 71, Rule 7, Sub-Rule 5. Page 71, my lord, middle of the page, Sub-Rule 5, Motor Vehicle Inspector, Pool Officers and Enforcement Inspector.
Yes.
Now, my lord, in small Roman 2, my lord, are the posts of Enforcement Inspector, my lord.
No, this is, see, that yes. This fact is taken on board.
Yes, my lord.
But the query is, now you have come at this point of time.
Yes, my lord.
Saying that the advertisement which were or are hitherto, in dormant stage.
Yes, my lord. Advertisement is, my lord, at page 82.
Advertisement. Yes, sir.
Page 82, my lord, annexure 12. This is, my lord, advertisement dated 14th of December 2020. Now, the relevant post, your lordship will find at page 87, serial number 18. Serial number 18, my lord, Enforcement Inspector, number of post 2. So, my lord, since there was no stay after this writ petition is filed, now the department is contemplating to proceed with the issuance of, my lord, for written examinations.
Where's the indication for that?
My lord, that has not been issued, but we have been informed. The department has, my lord, informed us that we are proceeding.
How can you, Mr. Nongwi, I fail to understand. If you have been informed verbally, where's the
Well, on the basis of, because my lord, if there's no stay, the 2020 advertisement has to proceed, my lord. And if the advertisement is to proceed, my lord, the selection process is to be completed, my lord, the entire writ will become infructuous, my lord, and the rules are infringed, my lord. The reservation of 33%.
But again, you said the whole the subject matter is under scrutiny by the Supreme Court, isn't it?
My lord, that is in a connected matter, my lord, in a connected matter. In a connected matter regarding the assistant enforcement inspectors, my lord. So it's somewhere connected, my lord. It's somewhere connected.
That is with regard to the cadre.
Yes, my lord. Now we cannot proceed with this because of the Supreme Court matter, my lord. In the meantime, department will proceed with the advertisement, my lord. Everything will be defeated, my lord.
Yes, Mr.
May I submit, your lordship? Lordship, in fact, the locus and the maintainability, your lordship, has to be seen, your lordship. First, what happened, your lordship, in this case, these are the petitioner here in your lordship. They are enforcement checker. So in 2014, they were promoted to assistant inspector, assistant enforcement inspector. So those selection and their promotion came to be challenged by those people who have not been given the promotion, and that means the undergraduate, because these petitioners are graduate. So, your lordship, what happened? Then the writ petition, your lordship, was disposed of, and then against that, your lordship, setting aside the order of promotion. So both the state as well as the petitioner as appellant file writ appeal, your lordship. So, your lordship, by the order dated
510.
Lordship, can you bear with me?
4/9/2018.
Lordship, that has been upheld, your lordship. So, in view of this judgment passed by the division bench, your lordship, in which your lordship will say part of the bench, your lordship. So, in my humble and respectful submission, now the petitioner has been reverted back to the post of checker, enforcement checker. So he will not have the local standi.
So he will not have the he will not be entitled to be promoted.
Yes, your lordship. No, because if the advertisement is held also, your lordship, he will not be eligible to apply for the post in view of the fact that he's a mere checker, because the advertisement here is called for the
inspector.
Yes, your lordship.
May I explain, my lord? My lord, if your lordships recorrect.
Just a minute, please. Okay. Then the fact that a submission has been canvassed that the matter is pending before the Honorable Supreme Court. That is true, your lordship. But so far, your lordship, there is no stay of the proceeding here, your lordship. It has been filed, your lordship. There is no stay, your lordship. Can you see, your lordship? This is the advertisement of 2017-2020, your lordship.
Lord, may I, my lord, address that point? My contention in this writ petition, my lord, is, my lord, in those proceedings, there were two groups. My lord, one group who are graduates and one group who are non-graduates. Non-graduates came to this honorable court saying it has to be in terms of seniority. The other group contested saying no, it has to be in terms of the qualification, my lord. Now, my lord, either ways, my lord, these two petitioners, either ways, even by seniority, they are eligible. Even by as graduate also, they are eligible, my lord. So, my lord, they have something at stake, my lord. If the government decides to appoint them, to promote them by way of promotion, my lord, by seniority, these two petitioners will get. They are number 2 and 3.
What is your status now? You are functioning as
enforcement checker.
Checker, my lord.
Checker,
my lord.
Okay. So your next promotion will be assistant
enforcement
inspector, my lord. So that issue is pending.
Thereafter,
Thereafter, enforcement inspector.
Enforcement.
And the advertisement is for enforcement inspector.
Inspector, my lord. And my contention is this: we are for we are in the contention for promotion, my lord, by way of promotion. Now, these posts of 33% is reserved for us, my lord. If we don't come, my lord, who else will come, my lord?
See, Mr. Nomri, what Mr. Shulai said is correct. Now, first you have to overcome, the difficulty of you being considered for promotion as, or to be confirmed rather, as Assistant Enforcement Inspector.
Correct, my lord.
Since now you have been reverted back to the post of checker by
Correct,
virtue
my
of the court's order.
Correct, my lord.
So,
Now, my lord, my contention is this. Assuming that we have been reverted back to checkers, now there's no stay by Supreme Court. There's nothing stopping them to promote by way of seniority, which I will definitely get, my lord, because in terms of seniority also I'm number 2 and 3. They're not doing anything, my lord. They're sitting over it, and the posts which are reserved for promotion, they're advertising it, my lord. My lord, there's some illegality being carried out. Somebody has to point out to this honorable court.
that is true.
Yes, my lord.
But
Either, my lord, either they comply with the judgment and give me promotion, I will get it by way of seniority also. That also they're not doing. I've made representation to that effect. They have to take a call. If they have to comply with your lordship's judgment.
first, whatever the case may be, let's put it this way, if I understand correctly, if the Supreme Court decide the matter, so your position as Assistant Enforcement Inspector will be confirmed.
Yes, my lord.
So,
Yes,
then you will be at that position.
Yes, my lord.
Thereafter, if you are to be promoted as Inspector, then it will be a matter of course.
Yes, my lord. Just for a correction, my lord, I have not approached Supreme Court.
You have not.
I have not. I have not, because it does not affect me. By seniority also I can get, and I have prayed for that, and they're not considering that, my lord. By way of
You have not approached this Supreme Court, no doubt.
yes, my lord.
But by virtue of this court's order, you have been affected.
I have been affected, but then I still benefit from the other side also, my lord. By seniority. By seniority, I'm number 2.
Whatever the fact, whatever the
ma'am.
case may be, the fact remains that you are checker now.
Yes, my lord.
So you cannot, by any stretch of the imagination, be considered for promotion or even for appointment by direct recruitment to the post of Inspector, Enforcement Inspector.
I cannot, my lord. I cannot.
So
I
where's
cannot.
your-
But I have to
where's your
safeguard my
grievance?
interest of promotion, my lord.
As and when,
Because,
as and
my
when
lord,
it comes
assuming-
up, you see, as and when it comes up, it will be incumbent upon the department
My lord, once
to make provision.
once the selection process is complete, my lord, 100% post will become direct recruitment, my lord. Then there are no posts available for us, my lord. That is why, my lord, they have framed the rules during pendency of those petitions, my lord. Now they are violating the same their own rules, my lord. That is what I'm indicating. I'm not saying appointment to the post. I'm saying you reserve that post for us.
But will that be, possible?
All I'm saying, my lord, till such time this matter is heard, because this matter will have to be heard on merits, my lord.
Yes. And what is your prayer in this petition?
In this petition, my lord, to quash the advertisement, my lord. Why? Because these posts are reserved for promotion. I'm not saying appoint me against those posts. I'm saying they cannot fill the post by direct recruitment, because 33% under the rules is reserved for promotion. That is my prayer, my lord. So, my lord, your lordships, my lord, at page 7 of my application, in the connected writ petition, had issued certain interim orders, my lord. Similar orders may be passed, my lord.
I think, Mr. Shulai,
Lordship.
on the basis of apprehension and legitimate expectation, I think you have to.
That is the only hurdle, your lordship, because they are yet to cross one step of the ladder. Lordship, the interim order passed earlier also in writ petition 46, your lordship. As on the date when this order was passed, your lordship, yes, they are. They were assistant inspector, enforcement inspector, because the judgment of the division bench was
subsequent to this.
Subsequent, Your Lordship, on 21st/3/2022.
And the writ petitions were filed on the same date. Writ petitions were filed on the same date.
Lordship,
Interim order was passed only in 1 month.
Lordship, the result of the selection in pursuant to the advertisement 2020 may be subject to the outcome of the writ petition.
I'm asking for similar orders. That's it, my lord.
Because the MPSC also, they are not here, because this is a petition filed in a pending proceeding, Your Lordship.
Oh.
Up to what stage of the
Exactly,
advertisement also, I'm not aware, Your Lordship.
That was the query of this court at the outset, as to at what stage is the proceeding. And
Lordship will have to ask them to.
That is why
issue
my
not
lord, I
up
prayed
to
that
share
notice
copy.
may be issued, my lord. That is why I prayed. But Mr. Shulai wanted to make his submissions, my lord.
so you take steps, Mr.
Yes, my lord. In fact, we have served Mr. Paul. We have served him.
Heard Mr. Piriman Nongri, learned counsel for the petitioner. Mr. Additional Learned AAG has accepted notice on behalf of the respondent 1, 2, and 3, respectively. The petitioner is to take steps for issue of notice upon the respondent number
4.
Your Lordship.
My lord will serve through standing counsel. They have a standing counsel.
That's
with
up
the
to, if they acknowledge service, then
My lord.
that is okay.
My lord may just say serve through standing counsel, my lord.
That
Because otherwise I will have to take my lord, regular steps.
you do it
My lord.
if at all they accept notice,
My lord.
or simultaneously you
I will
take
do
step by
that.
the usual method.
I will do that.
In the meantime, as prayed for by the United Council, the petitioner, any further proceedings as regard the advertisement number MPSC so akan kapriya pa no is hereby put on hold till the respondent MPSC is heard in this matter.
Lordship, the main writ petition will be listed on 21st.
Yes, so that will not let it come. Because that again the prayer has been made time again that subject to the outcome of the.
So this miscase also, sin notice has been issued, Lordship. It will come on the same day. It will come on 21st. It will be better, Your Lordship, then on that.
Let it proceed separately, it's okay. Because on 11th of May, the main matter was adjourned for 10 weeks, my lord. So that may not.
10 weeks.
10 weeks. So it should be. It can come along together.
Mr. Shulai said it is coming on 21st.
21st is coming.
Lordship, as per the system of the.
Okay, so
21st.
this is matter on 21st.
So that.
Yes, I think it will not be confusing.
Yes.
Otherwise, miscase on a different date, then main repetition another date. That is the only for convenience, Your Lordship. Highly apply, Your Lordship.
Item number 3.
This is the archery matter.
Yes.
There's some other matters in the main list also, my lord.
So,
In fact, I was requesting if my friend agrees, my lord.
I'll be brief.
No, Friday will be relatively free, my lord. We can argue on Friday. Day after tomorrow. In fact, today too many matters were listed, my lord. Some I prepared, some I could not.
see, archery, if I understand correctly, it's a game of luck.
Now GST 28%.
So either you're pushing your luck or you're trying your luck. We'll take it up after 1 week then.
Lordship.
We'll take it up after 1 week, not on Friday.
The only thing is, it takes time for.
Today is
12.
12. We'll take it up on 18 then.
May I just express a difficulty? It takes a lot of time to prepare these matters because they're two connected matters. Well, the second matter is also quite voluminous. I have already prepared. My learned senior friend had agreed that I could complete my part of the argument. I'll be very brief. I have just 3 or 4 more judgments to place before Lordships. If Lordships permit, I'll complete it today. They can respond on the next date.
Okay.
If Lordships only permit that much, I'll complete it. I'll be very brief.
Fine.
Lordship. So I'll complete it today, my lords.
At the end of the board.
At the end of the board.
After the other matter.
Obliged.
Lady Costless, item number 1. May it please your Lordship. Lordship, we are for the petitioner. We were supposed to file our rejoinder, but the conducting counsel is out of station, your Lordship, due to some personal difficulty.
How long?
3 weeks' time may be granted.
On pre-made by the petitioner, seeking further time to file the rejoinder affidavit. Matter is adjourned. This is same after 3 weeks.
Highly obliged, your Lordship. Item number 2.
Should I'm praying for another 1 week time. I will rejoin.
You're for petitioner?
For petitioner.
Mr. M.L. Longpure, counsel for the petitioner, has once again sought for some more time to file the rejoinder affidavit. As prayed for, this is matter of the 3 weeks.
Item number 3.
Lordships, I was to give a brief rejoinder to the arguments that have notices have been served.
Yes. Now, who is appearing for whom?
Correspondence number 4, 5, 6, 7, 8.
Four, 5, 6, 8 and?
5, 6, 7, 8
and who's for 9?
Lordship, 9 is the Pollution Control Board. They have not been appearing right since the time we filed the writ petition. No notice was served then, even in.
But have the acknowledged notice, Mr. Sai?
Actually, we had already served for the spot number 9, and they had acknowledged.
Have you filed any affidavit of service?
No, we'll be filing the course of the day with your permission, my lord.
Mr. Sai, we have to wait for the respondent 9 to appear.
As your Lordship pleases, but they have acknowledged we can place that affidavit in the course of the day.
File your affidavit of service.
Lordship, we'll do that.
We'll take up the matter on Tuesday then.
As your Lordship pleases.
Lordship, as I had also brought your Lordship's notice, and it is a statement by them that their applications are being processed in the advanced stages, and I have no protection whatsoever from any court.
In the meantime, status quo will remain as of today.
Maybe recorded.
So far as status quo is concerned, Lordship, I have some difficulty, and I may make that good, because the entire issue before your Lordships today is that whether they could have at all instituted the suit without having given a notice under 80.
That is the issue.
Presently, and the appropriateness of grant of leave by the trial court is being tested in these proceedings. Now, if Lordship were to order status quo with greatest of respect, that would in essence be granting the interim relief, which they have not yet even opened their case on the interim relief before the trial court. So today an order of status quo would be virtually allowing their 39.
No, Mr. Sai, so as to safeguard the proceedings as such, status quo as of today till the date the matter is heard.
Lordship,
So
then,
the matter will,
difficult.
let's put it this way, matter will be heard on 18th.
I see that, Lordship, but the status quo order would in fact interdict the entire process. Now, these are coal mining applications where both the central government and state government have been working at it for 2 years plus. And Lordship in the full bench is already seized of the matter that these are.
Mr. Sahai, if at the end of the day you are found to be amiss, then nothing can be done about it.
Surely, Lordship, the process would have to then be redone. But at least in the interim period, the progress has been substantial. And if it were to be stopped, because otherwise I am prepared for the arguments in the matter. My friend has already closed the arguments. The PCB in any case is not presenting itself even before the trial court, as my friend said. If it serves any purpose, I can make a statement that the PCB, I am not pressing any relief against the PCB in these proceedings, because a status quo order would
even then, Mr. Sahai, if you are not pressing against respondent 9, then you have to make a formal application for striking them off. So that will
if Lordship could grant me an indulgence and record my statement that I am not making any prayer against the PCB and permit me to rejoin, because a status quo order would be, it would be granting to the, I would be worse off for having filed the CRP. Today I would be worse off for having filed the CRP, something that the petitioner has not got in the trial proceedings, he would be getting without even opening the case. And that, Lordship, I believe it would be putting me in a very prejudicial sort of a position. That's my only difficulty. Otherwise, if they were enjoying stay, I in any case would not have said had any opposition to that. But neither can I make a statement on that. And in my respectful understanding, Lordship, having filed the CRP before the trial court, they have no interim protection. They are without interim protection for the last month. They were granted only 3 weeks to approach the trial court. That 3 weeks has long since expired. The trial court has not deemed it appropriate to consider the interim reliefs till date. So therefore, whether it is a status quo for a period of 3 days or 4 days, it would still be, in my respectful submission, Lordship, putting me at a considerable disadvantage for having filed the CRP. Otherwise, I would have contested the 3912 before the trial court, and in fact, by now there would have been a decision perhaps on the 3912. So, Lordship will consider my predicament. I would not have insisted this much had it not been for the fact that it would be completely upsetting the scheme of how the matter has progressed.
Fine. So we'll pursue with the matter, and on your prayer to strike off the respondent 9, it will be done so.
Lordship may record my statement. The PCB is not, that I will not be pressing my reliefs against the PCB.
Lordship, I am not being able to press my applications in the lower court because it was mutually decided here along with my friend that till this matter is not disposed of. Either way, we will not be pressing any applications over there. And on the last date also, when we have appeared, that is the same decision that has been taken, that
neither party should.
We told the court that after this matter is decided, we'll go ahead. But Lordship, the core issue here is the permission applications that is being processed. Now, though the state and the center have been working tirelessly for the last 2 years, I respect it. Maybe for the betterment of the state, but at the stake of my rights, that cannot be accepted. Sir, let me complete. If it is until this Tuesday, it will not cause much harm to anybody. And as far as the pollution board goes, Lordship, they would be taking an active part in the public hearing process, which will be a process which is detrimental to the further progressing of the applications. That is why we have made them a party in all the litigations that we have initiated till date. So, Lordship.
Yes, because the necessary clearance has to be given
from the pollution board. Now, Lordship, all I am praying is, where do I go? They filed this CRP. We didn't file it. We have been diligently trying to pursue the matter in the court below, which is seized of the matter. Now, Lordship, they were supposed to serve the notice on the last date. In fact, they were supposed to serve the notice prior when they were filing the litigation, which they did not. Then we had a full-fledged hearing. Today the matter was supposed to be taken up for disposal. Now they are saying they have served it and they have not filed any affidavit to show that they have served it. So either they are trying to delay or they are trying to go around the process where I am exposed. So they have filed this CRP. They wanted us not to pursue the matters in the lower court till this CRP is disposed. We agreed to it. Now it is for their fault that we are not being able to take this matter today for disposal. So all I pray is, whether it is fixed until for tomorrow or till Tuesday, Lordship, as Lordship is of the view initially today that status quo may be made so that they don't process the application. Because Lordship, where do I go for a relief? And if it so happens that on Tuesday they come and say that the application has already been processed, the subject matter of the case below, it becomes infructuous, Lordship. I cannot pursue it any further. So
Lordship,
I'm also praying. I'm praying for justice.
I'll only say this much, that my friend has filed a title suit. He has filed a title suit in the court below. There is no question of his suit being being rendered infructuous on account of a permission granted in the opposing land. It's a title suit where he disputes the title of the private defendant. The suit will very much survive, because ultimately it is for him to demonstrate by way of trial that it is his title over the land and no one else's. That in any event in a title suit there is no question of any interim order of sorts. So the case before the court below is a title suit. It has nothing to do with the permission process. My friend, by linking it to the permission process, in essence, unless he demonstrates that he has title over the overlapped parcel of land, he cannot get any relief, and that demonstration can only happen post trial. So if today Lordship is the court will not grant an interim order for the asking so far as the plaintiff is concerned, because the plaintiff has in fact yet to demonstrate the entirety of his claim over the disputed land. The permission is one facet of the proceedings, and we are aggrieved by the fact that the permission process would require them to issue a notice under 81, and only then he could sue the government. And that is the limited remit of what is before the court. Today, by representing again and again that the permission will be granted, my friend is seeking to give an impression that the suit would be rendered infructuous. That cannot be. It is a title dispute. A title dispute may always continue. No title can be handed over by an interim order. The permission on that land will not grant title to the private defendant. I'll leave it at that, Lordship. But so far as my initial suggestion was, I have the papers to demonstrate. I have the stamped receiving also. Only for want of an affidavit, if the proceedings are being deferred, I have no interest in deferment of these proceedings. I have the proof of service before in court. I can in fact tender that across the bar also if Lordship permits. But if that has to come by way of an affidavit, I will place that by an affidavit. But no interim order should be passed.
Yes. I have two submissions to make, my lord. Firstly, this is a revision filed by the state, my lord. Now, on their revision, my lord, respondents, any kind of relief in favor of respondent, my lord, that in my humble submission will not be proper, my lord.
Yes,
Either
that has to be.
gets a relief or petitioner doesn't get a relief, my lord. Any status quo at this stage, my lord, will be akin to granting a relief to respondent. My lord, that's my first submission, my lord. Second submission, my lord, the matter is, we are ready to argue the matter even tomorrow, day after tomorrow, Monday, Tuesday, my lord. In 5 days, it is highly unlikely that permission will be granted and mining operations will start in 5 days. But my lord, our only concern, my lord, if any interjection by a court order in the process, my lord.
What we can do, okay, let's cut the process short. If Mr. Sahai can assure that the affidavit of service will be served today, we'll hear the matter tomorrow.
Lordship, I'll ensure that the affidavit of service is on record by tomorrow. And Lordship, yes,
the court.
The
court is well aware of the respective stands of the parties and also what is involved herein. But we still have to look at the core issue that is agitated before the court in this proceeding. So that's beside the point.
Only we agree that mining operations start. That, in my humble submission, is not going to happen in
Lordship, I am primarily aggrieved when the state is processing the mining application with so much of desperation, despite knowing the fact that there is an issue with the land. And it is their DFO who initiated the whole overlapping process.
But that is not the issue here, Mr. Kera. The issue here is whether you, by virtue of your application or rather by virtue of your exemption,
Lordship.
Whether the suit will lie or not as regard section 80, 81 or 82, whatever the case may be. So
Taken up tomorrow in that case.
That limited extent, the court will decide on it.
Lordship.
So tomorrow.
I'm so grateful to my lords. I apologize for the inconvenience on my part.
Heard Mr. S.I., Letter Counsel for the GA, appearing for the petitioner. As far as respondents 4, 5, 6, 7, 8 and 10 are concerned, they are duly represented by the Leonard Senior Additional GA, Additional Senior GA, Mr. A.H. Karwalam, Mr. Dr. N. Musica, Leonard DSGI, has also entered appearance on behalf of respondent 11 and 12. What is left is the respondent 9, who has not yet entered appearance before this court. The Leonard Counsel for the petitioner has, however, submitted that the notice has been duly served upon the said respondent, but the affidavit of service could not be filed today. It is prayed that the same may be allowed to be filed in course of the day. Pray aloud. On prayer made by the parties, this is matter tomorrow. This is matter for hearing tomorrow.
I'm so grateful.
Item number 13.
The only thing is that tomorrow we have that full bench matter and some other matters. I know. So
Lordship.
We'll have to play it by ear.
Yes. I'm so grateful.
Item number 13.
May it please your lordship, on the directions of this honorable court, the copy of the CD has been received and also the status report, lordship.
What is this case about, Mr. Sheikh?
Lordship, here, lordship. Your lordship, the FIR is at page 10, lordship. Here the allegation is that
it's a case of Dagoiti.
Dagoiti, yes, lordship.
Dagoiti, lordship, and lordship, as per the status report, it's already charge sheeted, lordship.
Charge sheeted?
Lordship.
So,
charge sheeted, lordship. When did that name?
Charge sheeted since 5th of July, lordship.
Today we are on.
Today we are on the 12th, lordship. The last paragraph, lordship. Further, based on the evidences, a charge sheet submitted Pulbari PSCS number.
You're reading from?
Just the instructions, my lord. Just at the last part, lordship. Not from the CD, lordship, but just the yes, lordship. Based on the evidence, charge sheet submitted with regard to Pulbari PS case number.
You're reading from your status report?
Yes, lordship. Just the last portion, lordship.
Last portion.
That has been charge sheeted, lordship.
Para?
Last paragraph, lordship. Further based
22.
on
Okay,
of
okay.
page 4,
Yeah.
Lordship.
Yes.
Lordship. That has been charge sheeted on 5th of July, Lordship, 2023.
Have you received? So you're yet to receive
Yes,
copies.
Lordship, he is inside the jail because there are 3 accused, Lordship, and out of 3 accused, Lordship, 2 has already been released on bail on the earlier occasion, Lordship. Because then I approached this honorable for 438, Lordship, and 438 was rejected because the prosecution raised the objection because my car and my driver was involved, alleged to have been involved in the commission of the offence. And another ground, Lordship, they have raised the objection saying that because some gold articles were seized, which they have claimed that these are the stolen property, Lordship, from the residents, from my residents. But if we go through the FIR, Lordship, the allegation in the FIR with regard to the gold jewelry, Lordship, amounting rupees 10,000, whereas the police have seized some golds, more than 50,000 rupees, some earring, Lordship, 4 or 5 from my residents. That is also one of the basis for putting the allegation against me that I was also involved in the commission of the offence, Lordship. And that was the reason for rejection of my anticipatory bail application. Then on the very day, Lordship, I was arrested. That is on 28 April of this year, Lordship. And it has been more than, today is 76 days, Lordship. 76 days, Lordship. Now my only the thing is that I am a permanent resident of the area, Lordship. If my Lord only strict condition is put to ensure my appearance so that I'll not evade the trial, Lordship. That is the only aspect, Lordship. I am ready to comply if any condition is put, Lordship.
Lordship.
And that FIR has been filed after the filing of the bail petition before this honorable court. I have filed the bail petition last month, Lordship.
Finished. May it please, Your Lordship.
Let's look at the sections.
Lordship, 397, 395,
397,
395,
7 years.
Lordship. 395 is 10 years, Lordship. The Koiti.
$397, not less than 7 years.
395 and 34, Lordship. Lordship, if I may apprise this honorable court, Lordship, there's another accused person, Lordship, and he is still evading arrest till date, Lordship. So the police are still trying to arrest him, though he's absconding, Lordship.
That would have no nexus.
No, Lordship. What I'm saying is that, Lordship, in the at the last instance when anticipatory bail had been filed by the accused person, Lordship, the prosecution has also made it known to this honorable court that there was another case pertaining to the same accused person in Halideganj, Lordship, with the same route, the Koiti matters, Lordship. That's why we had strongly objected to the anticipatory bail also, Lordship, and that's why this honorable court was pleased to dismiss the anticipatory bail application, Lordship. Lordship, at this juncture, Lordship, because he has been arrested on the basis of his own statement and the statement made by his father, Lordship, which led to the recovery of the stolen ornaments as well as the cash. So, Lordship, at this juncture also we object, Lordship, because they are still, though it's charge sheet to the extent of his participation in the dacoity, but there are other things to be recovered also, as well as another accused person.
My Lord, with regard to the another case, that cases are already been charged sheeted. I am facing trial, Lordship. I am facing trial. It's not that I am evading the arrest, Lordship. And so far as the seized gold articles, what my learned friend is saying, Lordship, if my Lord kindly see the FIR, Lordship, that is at page 10. That stolen articles, what my learned friend is saying, that yet to recover some stolen article, Lordship. With reference to the page 10, Lordship, that is the type copy. With reference to the subject cited above, I have the honor to report you that on 18/6/2022 at around 1 a.m., a group of 7 dockets break into my house, tighten my hands and feet with cloth, warned me with dagger to abstain me from making any kind of sound, Thereby they looted gold and silver ornament amounting approximately rupees 10,000. After that they have entered. That is the articles they have alleged that I have stolen from that the dacoits have stolen from the informant lordship. But police have raided my house and seized 4 or 5 earring lordship. Whereas in the complainant, they said that silver and gold amounting rupees 10,000. But that was one of the basis of the prosecution to raise objection for cancellation of rejection of my
No, you are mistaken.
pre-arrest bail lordship.
Yes, one at a time.
That was the main ground lordship. And moreover, lordship, I have been inside the jail for 76 as of today, lordship. My only the thing whether I will evade the trial or not. If lordship any strict conditions, I am a permanent resident of that locality, lordship, I will not run. Since the case is proceeded for trial, I am ready to appear, lordship, on each and every date, lordship.
Lordship, I strongly object, Lordship, because he was running. It was only when the anticipatory bail was application was dismissed by this honorable court that the investigating agency could arrest him. Lordship, with regard to the submission, with regard to the gold and silver, approximately 10,000, that was not our ground for objection to the anticipatory bail application. Our main reason was that the father of the accused had stated before the police, had given statement before the police, Lordship, that his son had confided in him that he had participated in the dacoity and had asked him to keep the looted money as well as whatever items were there, Lordship, in the safekeeping of the father. And that is on record, Lordship. This was also produced before this honorable court on the last occasion, Lordship. It was on this basis that we have submitted, Lordship, before this honorable court. Why we have objected? Because, Lordship, they are habitual offenders when it comes to the dacoity, Lordship. And this is not a crime against one person. It's a crime against humanity, Lordship. They don't have specific targets. They target easy targets, Lordship. That's why we strongly object to bail when it comes to especially the dacoity, Lordship.
If my lords recollect that when I got the interim lordship for 1 week, in pursuant to the interim order, I have appeared before the IO for 1 week. 3-4 days I have appeared before the IO. Then when the CD was called, lordship, at the final hearing, lordship, that record was not placed. Then the prosecution was disputing my appearance before the IO, whether I have complied the interim order or not. Then I strongly submitted that I have complied. Then the court on the same day directed the IO just to bring the status whether I have appeared or not. Then lordship, on the subsequent day, he has through mobile somewhat sent the status report that I have appeared, and he was very instrumental to arrest me, lordship. And on the very day, lordship, 3:30, my lord, before the order was uploaded in the court website, lordship, and 3:30 before 4, I was arrested from my residence, lordship. So here also, my lord, kindly see, lordship, noted one thing. I have filed my bail petition here before the 90 days to expire, lordship, in order to block my bail, lordship. They filed the charge sheet. Hurriedly they filed the charge sheet so that I cannot get the bail, lordship.
These are all unfounded allegations, lordship. With regard to him participating with the investigating agency after anticipatory bail was filed, lordship, they have made a false submission before this honorable court. He had appeared only after some days on the date they had stated to have appeared. Lordship, if I may, lordship, because serious allegations have been placed, if the matter may come up tomorrow, I'll take along the file for the anticipatory bail also, because they are making very serious allegations, false allegations against the state, lordship. And this is not how the state functions, lordship. Habitual offenders, lordship, they can't just make submissions offhand, lordship. This is not how the state functions at all.
Here,
what is submitted is only with regard to his appearance before the
yes, lordship.
And it it was, they had stated that it appeared before the IO on the specific date. When I got the information, when I got the instructions, Lordship, it was not on the date as they had claimed. It was after, Lordship.
We'll not go into that
But
aspect.
they're making very serious allegations,
My
Lordship.
lord, here only that I am ready to face the trial, Lordship. Any strict condition may be given, Lordship would. Then so far as the other accused that the IO is yet to arrest, the other accused, that cannot be the ground to detain me, Lordship. 76 days, Lordship, I have been inside the jail. Whether any
Is
custodial...
charge let trial commence, Lordship, because they are habitual offenders. And yet it has been admitted, Lordship, that they're facing trial in another case also.
So the informant has not been able to identify anyone.
If I may, Lordship. Lordship, at my instructions, Lordship, at paragraph 20, that on 17/5, last page, Lordship, at paragraph 20.
Yes.
That on 17/5/2023, a prayer to conduct a TIP of the accused persons, Waliul Islam, also known as Aliul, and Nazir Amir alias Pata, submitted before the Honorable Court Dadengre, and the witnesses were positively identified in the presence of the Honorable Magistrate at District Prison and Correctional Services, Tura, Lordship. So the instant accused, Lordship, Waliul Islam has been Waliul Islam has been identified, Lordship, in the TIP.
Heard Mr. S. Sheikh, learned counsel for the petitioner. Also heard Ms. N.G. Shala, learned senior government advocate, appearing for the state respondent. The learned counsel for the petitioner has submitted that an FIR was lodged before the officer in charge, Pulvari Police Station, on 18 June 2022. By the informant therein, who has alleged that a group of 7 dacoits broke into his house and apprehended him. Thereafter, they looted possessions from the house, including gold, silver, and cash. Thereafter, they fled from his house, leading to the lodging of the said FIR. The police, on receipt of the said FIR, has registered the said FIR as, what is the case number?
That is Pulvari
Pulvari
PS case number 48, Lordship.
Pulvari PS case number 48, 6 of 2022 under section 397/395/34 IPC. In course of investigation, the investigating officer had made a number of arrests of suspected person who are said to be involved in the said incident. The son of the petitioner at the relevant point of time being apprehending arrest had accordingly moved this court by way of an application for grant of pre-arrest bail. The same was accordingly rejected, and the same was rejected by relevant order. The son of the petitioner was then removed to custody and is in judicial custody till date. In pressing for this application, the learned counsel for the petitioner has submitted that the accused person named Waliul Islam has been in custody for about 76 days or so, and as such he may be allowed to be released on bail, to which he will give an undertaking that he will abide by any condition imposed by this court. Ms. Silla, per contra, Ms. Silla, learned senior GA appearing for the state respondent, has opposed the prayer made on the ground that the offence involved are serious, inasmuch as it involves a case of dacoity, which is a crime not only of an individual or a private person, but rather of the society as a whole. Since investigation would show that the accused person herein is definitely involved in the alleged offence as stated in the FIR, and his antecedent is also doubtful, inasmuch as he is said to be involved in a similar case of dacoity in another case, and as such, if enlarged on bail, firstly he would pose a threat to society, and secondly, there is no guarantee that he will not resort to his previous habit. The learned senior GA has also placed before this court the case diary, wherein, as well as the status report filed by the IO, wherein the complicity of the accused person in question has been clearly established. It is also submitted that investigation is complete and the charge sheet has been filed on 5th July 5/7/2023, finding where is the charge sheet?
She was in flat.
So there are altogether 4 accused.
Yes.
Lordship.
Kununong. With the IO finding a prima facie case under section 395 well established against the accused person, against the accused person in question, against the accused son of the petitioner, and 3 other co-accused who have been similarly charged sheeted. Kadang tu je cak mat tu kalau kau portion as you add you want you. It is also something that during the course of investigation, the stolen property has been recovered from the house of the accused son of the petitioner on the leading of the petitioner himself, who is the father of the said accused person. Next one, in view of the facts and circumstances and the incriminating evidence against the accused person, it is prayed that this bail application at this point of time may not be allowed. This court has considered the submission made and is also aware that in bail jurisprudence, bail is usually granted unless circumstances shows otherwise, and jail is always the exception. The fact being that the liberty of a person cannot be curtailed in custody by or through custody. It is also well settled in a catena of judgment that the court, while considering the prayer for grant of bail, is to consider certain factors relatable to the fact situation. Such factors being the seriousness of the offence, and the like. On consideration of the submission made, as well as on perusal of the papers produced before this court, there is no doubt that prima facie the accused person is involved in the offence alleged. It is, however, subject to evidence as to whether he could be convicted or not. Be that as it may, in the backdrop of the societal concern and a message to be sent to the citizen to ensure peace and safety, as well as protection from criminal activities, this court would think it prudent to not allow the prayer of the petitioner at this point of time. This being the case, the prayer for grant of bail is rejected at this juncture. Since the matter is already charge sheeted, it is expected that the court would proceed with the trial in right earnest. If no evidence is recorded within 1 month from today, the accused person in question is at liberty to approach a competent court or even this court for grant of bail, which will be considered at the relevant point of time. The case diary produced before this court is hereby returned. Matters disposed of. We'll see after 1 month if nothing proceeds, and you ensure that trial commences.
Item number 14.
Your Lordship, consider having it after lunch today. And I was also checking on Friday, there's only one matter in the division bench. So relatively relaxed, Your Lordship.
So we'll take it up on Friday then.
On Friday or not?
On pre-made by the parties, place this matter on Friday.
Right.
So